Philippines, we have the bouncing checks law or the Batas Pambansa Bilang 22 or BP 22. However, some people often confuse Estafa with BP 22.
It has been established in decisions by the Supreme Court that the mere issuance of a bounce check, irrespective of your intent, whether it was out of good faith or you had a criminal intent to defraud another person, those are immaterial. Your intent is immaterial. So the fact that you issued a check that subsequently bounces is enough ground for you to be prosecuted for violating BP 22. It's meant to protect those who are receiving checks.
What is the difference between a check and a promissory note as a negotiable instrument?
Check is a form of a bill of exchange, which, in other words, is also a negotiable instrument. Now, it only means that when you talk about negotiable instruments, we're talking about commercial documents or instruments that you could circulate. So it's meant to circulate that document so that it is somehow recognized as cash. I mean, to put it crudely, a check is a form of a negotiable instrument, being a special type of bill of exchange.
What could be the reasons or legal defenses for persons who gave bounced checks? What are the requirements for a person to be held liable for BP 22 or Estafa? Can a person be criminally charged for BP 22? Good evening. You are watching Legal Help Desk on the Solar News Channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Attorney Nepomuceno. Tonight, we will discuss your legal rights on the issue of Estafa and bouncing checks or BP 22. What you need to know about Estafa and bouncing checks and what you need to do when you are a victim of it.
Our guest for tonight is Attorney Aquino-Tambasacan, prosecutor for the Manila Regional Trial Court. Good evening and thank you for being with us, Fiscal Rosil.
Pleasure's mine.
Good evening, Fiscal Rosil, right?
Yes.
All right. Now, a lot of non-lawyers, when you mention a law like Republic Act, whatever, or BP, whatever, they don't know it. But most non-lawyers know when you say BP 22, they kind of know it.
Yes.
It's one of those most popular laws, right?
I think it's one of the most common offenses
Yeah.
as well.
Yeah.
So, can you please tell us the difference? Kasi I think there's still confusion among a lot of people. Kung ano ba yung pinagkaiba if you file a BP 22 case and an Estafa case if a check bounces?
Yes, BP 22 actually penalizes the mere issuance of a worthless check, a bum check, meaning there is no adequate funds. On the other hand, Estafa, to constitute Estafa under 315 paragraph 2B, which is issuance of a bouncing check, you must prove that the check was issued with deceit, meaning you gave your money, in exchange for giving your money, you received a check as a result. So deception must be proven.
Okay, so that's the clear things there. Just in layman's term, terms, in pagkaliwaan, in other words, we have a transaction,
Yes.
and you give me the check, I give you this
That's
thing.
the reason for the issuance.
That's the issue of the issuance. The reason for the issuance. Then there's deceit
There's
there.
yes.
So Estafa right there. But let's say I'm paying you for a debt that I owe,
Previously contracted.
contracted.
Yes.
Then it's
That's
not
only-
Estafa.
No, that's only ordinary BP 22 case.
And if you're not sure whether you should file Estafa or BP 22, can you file both?
Yes, actually, it's the discretion of the prosecutor upon receipt of the complaint as well as the evidence annexed thereto to ascertain if this is a case of mere BP 22 only or a case of both Estafa and BP 22.
Okay. So it's safer. Would you
Yes.
advise
It's
our
safer.
viewers na pag hindi sila sigurado, file both Estafa and
Yes,
BP 22?
nothing is lost. There's no filing fee actually.
Now, what was the rationale for this? We already had Estafa.
Yes.
And would you be aware, at least familiar, Fiscal, of why there was a need for a BP 22, the mere issuance?
Yes, mere issuance, because to give credence to the issuance of a check. Otherwise, no one will be accepting checks for commercial transactions if they will not be correspondingly penalized.
Right. So it's more than just the act of no. It also undermines the whole system of
The
payment,
economic
right?
system,
The economic
commercial.
system. That's right.
And then, Fiscal Rosil, I'd like to ask you, what requirements do yung people who received bounce checks, what do they have to look out for in terms of making sure that their case will not be dismissed in court?
So the first step is to file a complaint with the Office of the City Prosecutor, because the City Prosecutor has jurisdiction over such cases. So you file your complaint, you annex or you photocopy the check, and you annex it to the complaint. You also add the proof of service that you indeed serve a copy of the notice to the party. So aside from the notice, you must submit the registered receipt or registered return card as proof that the other party had received the notice.
So the notice of dishonor, right?
Yes,
Yes, I'd like to actually delve into the notice a lot more, because
Yeah.
I've seen a lot of Supreme Court cases where the person who issued the bouncing check was acquitted just because they raised during the case that I did not receive any notice that nag-bounce na pala yung check. And
Yeah.
I guess it should be important for us to emphasize how important this notice requirement is. Maybe explain it na anong kind of notice ba yung kailangan?
The first requirement is a written notice. A mere oral demand is not sufficient. Second is that you must prove that indeed the notice was received by that person, and that is where the problem lies. Because the other person can easily deny receiving the letter. Say, I made ko nakatanggap, hindi ko natanggap yan. Or it's lost in the mails, then what is your defense? So that is a problem in this BP22 cases.
Yeah, so that makes it difficult, because even like, for example, as we were discussing it
Yes.
earlier, for example, if let's say the mailman delivered it to the houseboy or the maid or the son or daughter of the owner, and it was intended for the owner, that's not
That's not
notice.
sufficient.
That's not sufficient,
That's not
right?
sufficient.
They can't be even considered as authorized agents kung
No.
napatunayan that they're usually the people who receive the mail for the
For
person.
purposes of filing a case in court, the Office of the City Prosecutor will admit that as sufficient. But the problem is, when it reaches the courts, you must adduce proof that indeed this person received the mail, and that is very hard to prove.
Now, can you explain that further? I'm very interested in that, because you're saying that for purposes of the prosecution filing an information, it's sufficient.
Yes.
Right? But you're saying that when it reaches the court,
It's a different thing.
it's a different story. Maybe explain to our televiewers. No, they're lay people. How come
Yes.
sa prosecutor okay, and then pagdating sa court wala rin?
For the prosecutor's office, the only requirement is probable cause.
There you go. Okay.
In Tagalog, baka ang ibig sabihin nito ay baka nga talagang ginawa niya. So, we would admit as evidence sufficient to file an information, the notice of dishonor, together with the receipt or the affidavit if it is handed personally. But for purposes of criminal conviction, which requires proof beyond reasonable doubt, which is a higher quantum,
Right.
it must be established that indeed he received it 100%. That's where always the
Very
That's the reason.
tricky.
Okay. So I can imagine there are a lot of, I guess, dismissed cases in this
Yes.
case.
Or acquitted.
Acquittals,
Yeah, yeah.
actually.
Which is
Acquittals,
unfair
yeah.
kasi normally yung mga nag-i-issue ng bouncing
Yeah.
check, sila yung magaling magtago,
Yeah.
magaling
So,
mag-deny, di
so
ba?
technically, all you need to do is really hide, right?
Yeah.
Yes, actually that's a
To
problem.
be acquitted. Well, that's the
the
challenge
problem.
there, no? Okay, no. We have questions from our televiewers, and our first question is from Eunice, and she asks, my parents invested money to a family friend's business amounting to 2 million pesos. 2 years ago, the family friend went to Malaysia because that is where her business is located. Then the payment stopped. We have already filed a blotter and estafa case against her, but since she's in another country, how will our case against her proceed?
Well, considering that the case was already filed with the prosecutor's office, then the prosecutor's office will issue the appropriate resolution. And if it's beneficial for her, then information will be filed in court. Then a warrant of arrest will be issued. So if she's not abroad, if she's not here in the Philippines, she's abroad, when she comes back in the Philippines, a warrant of arrest will be issued against her. It will be enforced.
And Fiscal Rossel, I'd just like to look at a certain aspect of that question. It said na investment siya. Can the accused raise a defense and say, it's an investment, so yung pera naman talaga, hindi dapat sure na mababayaran? Is that a defense kung kunwari nag-issue na siya ng cheque?
For the issuance of a check, you don't look anymore at the reason for the issuance. No motive, just the plain fact that the check bounced. Nothing more.
Okay, that's good to know.
All right.
Our next question is from Barbie, and she asks, my father used all his retirement money and invested in a business. He was supposed to be a partner with a distant nephew. However, the nephew took all of my father's money and went abroad. We know where he is and have filed an estafa case against him, but my father has become depressed and sickly because of this. In addition to estafa, can we also file for damages? What other cases can we file against him? It doesn't sound like nag-issue ng bounce checks.
Yeah. Parang
No?
hindi.
Parang
hindi.
outright estafa? Would you call
Yes.
this just outright,
Outright
the
estafa. It's not a BP22 case. And the issue of the civil aspect for damages, when you file a criminal case for any criminal case for that matter, the civil aspect is deemed instituted unless there's a reservation. So there's no more any need to file a separate civil action.
So they can file a criminal case for estafa and then also raise yung amount of damages
Yes.
siguro for the amounts they
Plus
spent
nine.
for the depression and yung
Yes.
sa sakit niya, di
Mga
ba?
damages.
Yeah,
damages.
medical
Oo.
expenses. Okay.
That's right. All right. Now, I have a question now with respect to stop payment. Kasi common yan eh.
Yes.
Parang, hindi nag-bounce ang check ko. Pina-stop payment ko eh. Can you clarify that the law regarding stop payment procedures that are done by some people? No?
Yes, for stop payment first, it must be for a lawful cause. And the second requirement is that there must be sufficient funds. Kasi baka naman pinastop payment niya kasi alam niyang tatalbog. Walang laman, inunahan na niya.
Okay. So that's not a defense.
Not
Kung
a
ginawa
defense.
yun, tapos sinabi stop payment yung reason, they can still be convicted for BP22.
But if you say stop payment though, and let's say you didn't have a good reason, let's say you just changed your mind, but you can prove that you had
Yes.
sufficient funds. That's a
Yes.
defense, right?
Yes, it's a good
Alright,
defense.
So it has to be the two.
Yes.
Dapat
Fraud.
bad reason,
Bad reason.
or not a good reason, then
There's
proof
no
that
funds.
there's no sufficient
Yes.
funds. All right.
Okay. Another question I have would be, yung pag-issue naman ng checks, yung time from the time you get the checks and the time you deposit it. Kasi the others actually sometimes wait until after 6 months from the date na nakasulat. I've had friends come up to me and say, naloko ko because nag-bounce na, for instance, 1 year post-dated checks. And the first 3 checks already bounced, but the remaining 8 checks, hindi na nila dineposit because alam na nga nilang nagbabounce and they keep trying to contact the other person. So basically, they know na wala ng funds dahil nasabihan na sila the account has been closed. So what is your tip to the viewers out there? Should they deposit the remaining 8 checks bago mag-lapse yung 6 months?
It is a condition precedent that the check should have bounced. And no other better proof but to present the check which didn't bounce. And it's also a requirement during before the prosecution's office that the check had already indeed bounced and there's notice of dishonor. So how can you give a notice of dishonor if the check didn't bounce?
Okay. Let's ask Attorney Rosil more about
Yeah.
this.
Yeah,
For
very
now,
interesting
let's take
topic.
a short break. Legal Help Desk will return after these messages. You are still watching Legal Help Desk on the Solar News Channel, and we are still joined by our guest, Attorney Rosil Aquino-Tambasacan, prosecutor for the Manila Regional Trial Court.
Ayan. Okay, now let's talk about defenses.
Okay.
Obviously, most people's reaction whenever they get a complaint or maybe even a warrant for arrest for that, they'll say payment. So,
Yes.
when is payment a defense? Can you elaborate when they should be making the payment?
If they have made payment within the 5-day period from receipt of notice of dishonor, then that is an absolute defense.
Absolute defense.
Yes.
So, the moment you get the notice of
Yes.
dishonor, so you
Take
can
5 days.
rectify it, di ba? You
Yes.
can
So,
rectify it. Yeah.
for those viewers naman na in good faith, nag-bounce yung checks because hindi nila napansin na below the balance na pala,
You can
you have to pay within 5 days para you can raise that as a
Yes.
defense, para hindi sila makulong. And I'd like to go back on yung period when you should deposit the checks. Because other people naman, pagbigay sa kanila ng post-dated check, nakakalimutan nila i-deposit on time. And I guess yung importante dito would be to find out when does the delay in deposit become a defense for the person being sued or yung person na dinedemanda?
Yes, a check must be deposited within the 6-month period from check date. Otherwise, it would become stale. Moreover, the account holder must maintain funds within the next 3 months or 90 days.
Within 90 days. But what if you deposit ako yung binayaran. I have the check. I deposited it on the 4th month. Can the other person say, within the 3 months from the time I issued it, kompleto yung amount, it wouldn't have bounced. But since you deposited the money 4 months after, then kaya siya nag-bounce. Can the other person raise that as a defense?
No, actually, because it should be counted within the 6 months, then you add 3 months more.
Okay, so it's not a defense.
Okay. Now, one of the attractive features of BP22 for those, of course, who are victims of it, I mean, victims of bouncing checks, is that there's an imprisonment aspect to it, no? And I think a lot of people, they like to file this, lalo na kung na-victim sila, they want to file this so that because they have the impression that an immediate warrant of arrest is merited the moment they file a case and there's probable cause. Is that the case? The moment you find there's probable cause, can you issue a warrant of arrest right away?
Yes.
Or,
Yes, because in the information, there is a recommended amount of bail. So it means the warrant of arrest will be issued. And the amount of bail will be dependent upon the amount of the check.
But the warrant of arrest has to be, it will be I guess, issued only after you find probable cause,
if
right?
the information is filed.
It's not automatic now the moment
No.
I file a complaint or a complete affidavit sa prosecutor's office. Doesn't mean that automatically may warrant of arrest.
No,
There
because
has to
the
be,
Office of the City Prosecutor would have to assess the evidence if it would warrant the filing of an information.
Okay. And normally, yun nga, that's the fact that there's a possibility that a warrant of arrest can be issued against me. That's sort of like the fear factor there, no?
Yes,
At
inconvenience.
least insofar as those who issued it is concerned. Right? So,
Fiscal Rossel, I have another question. Kung the issuer of the check told you after giving you the check and said, don't deposit the money pala because I don't have sufficient funds. So I guess here you can't really prove na at the time this person issued the check talagang wala namang funds. But then, can this person raise as a defense that he was already informing the receiver of the check that not to deposit the money, the check, sorry?
Actually, that is not a defense. Even knowledge by the payee that there is no sufficient funds would not mean escape from criminal liability. The law does not look on the reason behind, just the fact that a check bounced.
Okay.
Now, when it comes to filing of fees, the rule before was if you file a complaint with the prosecutor's office, they had to file filing fees.
Yes.
Then after that, when you find probable cause and you file it sa court, another set of filing fees. Is that still the case?
No. Actually, 2 years ago, the filing fees for cases filed with the OCP had already been removed. So you will only file the filing fees in court.
Okay. All right.
And then another thing that I think our viewers should know would be the time periods when you might lose the remedy of filing this case. So
Yes.
what are the important time periods that our
periods,
viewers should take note of?
You should take note of the prescriptive period, which is 4 years from check date. Otherwise,
4 years from check
yes, the action already prescribed.
Okay.
Meaning, I guess
Can
for
no
our
longer
viewers to
file.
understand yung word na prescriptive, meaning if you don't do it within 4 years from the date of the check,
Yes.
then you can't file a case for BP22 anymore.
Now, given the difficulty as Karen had mentioned earlier, the difficulty sometimes of catching someone in the sense that they can always try to hide and not receive the notice. Because if I didn't receive the notice, which is a requirement in convicting someone under BP22, basically what happens is that there's usually an acquittal.
Yes.
Ano yung, what's the best way to ensure that there's some kind of teeth in this law? No? Kasi, like I said, if I was just a cunning individual and I issued a check, I can just hide. I can just hide and avoid. I guess this is not a question of legality, but more of practicality. How do you catch them?
Yes. Do not send notice of dishonor by mail. Send it personally, so that there will be a person who will execute an affidavit that indeed this person received it. So you have
What
verification.
if harap-harapan
harap-harapan,
iniiwasan?
iniiwasan,
Oo.
yeah.
Or alam mong nagtatago sa bahay, you know that the person lives there, he's there, except you made yung pinapaharap at sinasabi, wala siya dito.
Yeah.
Can the person, ako as, for instance, the complainant, state in an affidavit, I've tried so many times, I've been trying for 3 months, and this person just refuses. He's been hiding from me. What can I do?
Actually, that's the problem because the courts would not accept constructive notice. So, other people would do is that to call these persons before the barangay. And when they arrive at the barangay, not knowing what will happen there, then they will hand over the letter.
I see. All right, let's continue answering some questions. I think we have one from a viewer via phone patch. She's Maya from Novaliches. Maya, what is your question?
She's Maya from Novaliches. Maya, what is your question?
Yeah, my question is, we purchased a land and we didn't go with the deal because the owner changed her mind. Actually, instead of the price that they're asking for, when they found out we got a little bit money, they raised the price, so we didn't go through all the sales. What happened is, instead of the refund, they give us a partial payment, and the partial payment is a closed account. What is our recourse on that?
All right. Did you understand?
Yes.
Yeah. Fiscal?
Yes,
what are your thoughts on that?
basically she's asking what will be her remedy considering what she received was a check from a closed account in consideration for the return of the amount she had originally given. So her first her first remedy would be to file a case for BP22 because BP22 includes not only accounts with insufficient funds but also accounts or closed accounts. As regards the return of the amount of money she had already given, I think we have to take a look at what was the agreement. Because if that's just a mere contract of sale or an ordinary agreement, just an ordinary civil case will arise, not necessarily the criminal one.
All right. I hope, Maya, that we answered your question. All right.
We have another question from Amy, and she's asking, I wish to file an estafa case against a certain person. Is there a minimum amount of money before a situation can be considered for estafa?
There is no minimum amount. Any amount of money will do. Jurisdiction of the court would depend upon the amount of money involved in estafa. If it is below 200 pesos, that is a case falling under MTC. Above that, it's RTC.
Now, we mentioned when we were discussing earlier about this rule of the 500,000 rule.
Yes.
Below 500,000, you have the authority to issue a warrant, right there?
No, actually. If the amount is below 500,000, there's no more need to conduct preliminary investigation.
Yes. No more need to file or to conduct a preliminary investigation, and therefore you can
get a warrant.
Can get the warrant right away.
The case will be decided based on what was submitted.
Okay. Now, if it's above 500,000, you're required to have a preliminary investigation.
Yes, the parties
therefore,
would
notice
have
has to be given.
Yes.
Okay.
Right,
Fiscal Rossel, I think this is also a good time to clarify with people yung effect of issuing bouncing checks as opposed to just having utang na hindi nababayaran or debt that you don't pay, because a lot of people usually think that they can imprison someone for not paying the debts. So would you advise people to always ask for post-dated checks in return for any loans or utang?
Checks are safeguards as opposed to an ordinary debt where you can only file a civil case versus one which is supported by a check. You can file a criminal case for BP22, which includes also the civil aspect.
All right, we have a question naman from Richard on Facebook, and he asks, what if you were issued a check but found out it was not here?
Hers, I think.
Oh, hers, sorry. Hers. It's still BP22 if the account was not hers? We have one more question later on, but can you answer that question?
Yes. The requirement for BP22 is that it is the issuer of the check.
Okay.
So, since he said that the one who issued the check is not the account holder, then there should be no criminal violation for BP22, but a mere estafa, because the person who gave the check misrepresented that he owns the check. So it's estafa.
There was a deceit.
Okay.
All right.
We have another question from Eric, and he asks, how long can a person be jailed if found guilty for estafa? Is it bailable? And how much? How much is the bail? I want to file a case against someone who issued me a check for 200,000 pesos, but it bounced.
Okay.
Okay.
For estafa, the maximum imposable penalty would be up to 20 years. And it's a bailable offense.
Matagal pala.
Bailable.
It's bailable?
Yes, bailable.
Okay. Bailable, I guess, during trial, they can be out. Okay.
Can you issue a whole departure order for people who are found guilty, or at least there's a prima facie evidence for bouncing checks?
No, because BP22 is a case before MTC. And only those cases with the RTC can be given a whole departure order.
All right.
Okay.
Okay. Now, unfortunately, that's all the time that we have. We told you, no, the time is short here.
Yes.
But we would like to thank
Time
our
flies.
guest for tonight, Attorney Rosil Aquino-Tambasacan, prosecutor for the Manila Regional Trial Court. I'm Attorney Nepomuceno.
And I'm Attorney Karen Jimeno. Join us again next Monday as we discuss your legal rights. Good night.